Hello everyone, I am Isha and today we are discussing workplace laws in India for women. Welcome to our presentation on workplace laws in India for women. In recent years, there has been a growing awareness of the need for gender equality in the workplace, and India is no exception. Despite progress being made, however, many challenges remain. According to a recent report by the International Labour Organization, only 27% of Indian women participate in the labor force, compared 82% of men. Furthermore, women who do work in India often face discrimination, harassment, and unequal pay. The purpose of this presentation is to explore the laws and regulations that protect women in the workplace and to highlight the importance of these protections. Now, the Constitution of India. The Constitution of India provides for equal rights to men and women in all spheres of life, including the workplace. The fundamental rights enshrined in Constitution prohibits discrimination on the basis of gender and guarantee equal opportunity to all citizens. Article 15 Clause 1 prohibits discrimination against any citizen on grounds of religion, race, caste, sex, or place of birth. Article 16 Clause 2 ensures that no citizen shall be discriminated against on the grounds of sex in matter relating to employment. In addition to these fundamental rights, there are several laws and regulations that protect women's rights in the workplace. The Equal Remuneration Act 1976 mandates that men and women should receive equal pay for equal work. The Maternity Benefit Act 1961 provides for maternity leave and other benefits for pregnant women. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 protects women from sexual harassment in the workplace and provides for redressal mechanism. These laws ensure that women have equal opportunities in the workplace and are protected from discrimination and harassment. The Maternity Benefit Act 1961. This statute provides several benefits to the ambitious mother who also enjoys her work and does not want to start over after her pregnancy. It offers women with 26 weeks of paid maternity leave as well as 1 month of paid leave for illness caused by pregnancy or miscarriage, as well as a medical bonus of certain amount is to be given if the employer provides prenatal and postnatal treatment. If the employee provides proof of delivery, the payment is made 48 hours in advance and the employee dies without a legal heir, the maternity benefit will be paid to a designated beneficiary. No establishment may recruit you for 6 weeks following delivery, miscarriage, or medical termination of pregnancy under this act. While you are on maternity leave, you cannot be fired by anybody. This act removes the fear of losing their jobs because of pregnancy. The Mines Act 1952. A law was enacted to revise and consolidate the Mine Work Safety Regulation Law. Mine means any excavation in which work is or is being carried out for the purpose of discovering or extracting minerals. All open pits, railways, trams, sidelings, all levels and slope levels below to mines belong and all shafts associated with the mine. This includes a ban on night work, which stipulates that women can work from 6 a.m. to 7 p.m. It also requires an interval of at least 11 hours between the end of the day's employment and the start of the next period of employment. Prohibits work in hazardous occupations, nurseries, toilets, and urinals, and other general provisions of this act. The Equal Remuneration Act 1976. The Equal Remuneration Act 1976 will help close the pay gap of our country's women's face. Article 39 of the Indian Constitution allows for the demand for equal pay. Employers must pay men and women equally for the same work. Employers are also prohibited from discriminating against women in the hiring process except for certain posts. Equal pay for women and men to break down prejudice against women and treat both sexes equally and fairly. The Central Industrial Relations Machinery was responsible for enforcing the law. Articles 4 and 5 of this law refers to equal pay or wages for men and women in the same position. The Sexual Harassment of Women at Workplace Act 2013. Sexual harassment in the workplace is considered a violation of women's right to equality, life, and liberty. It fosters a precarious and hostile work environment that discourages women from working and impacts the goals of women's socio-economic empowerment and inclusive growth. The law defines the sexual harassment as any form of unwanted sexual conduct, including physical contact, advances, soliciting sexual favors, sexually innuensive remarks, pornographic depictions, or any other physical, verbal, or non verbal sexual conduct that is undesirable. Defined as act or action, any unwanted sexual activity is considered sexual harassment. An internal complaint committee should be established in accordance with legal standards. The Commission, upon receipt of a complaint, may attempt to resolve the matter through mediation between the complainant and the respondent. If a solution is found, no further investigation will be done. If the arbitration is unsuccessful or if the difference fail to comply with any of the settlements clause, the Commission will continue its investigation. Few case laws. One of them being is Vishakha versus State of Rajasthan. In this case, Bhavri Devi, a Dalit government official, organized cleanup awareness campaign and campaigns against child marriage and dowry as part of her job. She is assisting a young woman whose parents pressured her into an early marriage. She organized a demonstration and tried to stop the marriage from happening, but she was unsuccessful. In retaliation for the protest, a group of people attacked Bhavri Devi and as she and her husband were walking down the streets. These men gang raped the victim. After that, she accused those men, claiming that they raped her. Despite this, neither the police nor any law enforcement personnel paid her any attention. The five men were found guilty by the Rajasthan High Court of assault, which has a much lower sentence than rape. In response to the Rajasthan High Court's decision, a number of organizations that work to ensure the safety of women and the general public staged protests and marches. As a result, Bhavri Devi was compelled to receive government's and court's justice. That followed the Vishakha versus State of Rajasthan case, which resulted in the Visakha guidelines being created. The description of sexual harassment, the creation of a safer workplace, the establishment of a complaint handling committee, the obligation on the employers to file a complaint, assistance for the victim, increased public awareness, and the expansion of the guidelines scope by the government are all part of these guidelines. Another case is of Santa Kumar versus Council of Scientific and Industrial Research. In this case, the petitioner first complained to the International Criminal Court about the fact that she was in the laboratory. The third respondent then entered, pushed the petitioner out of lab, locked it, and even used offensive language. The committee's investigation revealed that the complainant was administrative and managerial rather than sexual. Santa Kumar then challenged the ICC's action in a writ petition filed with the Delhi High Court. In this case, the Delhi High Court said that as long as the physical contact was made in the context of sexually explicit behavior, it would be considered sexual harassment. In addition, it was observed that if unintentional and unwelcome touch would not constitute sexual harassment because it clarified the meaning of the term sexual harassment. This decision is significant. It might also deter people from making false accusations to annoy or intimidate the accused. In conclusion, it is clear that workplace laws in India play a crucial role in ensuring gender equality and protecting the right of women. The Constitution of India guarantees equal rights to women in the workplace, but there are still issues such as sexual harassment and unequal pay, that needs to be addressed. Maternity benefits provided by the law in India are a step in the right direction, but more needs to be done to ensure that women are not penalized for taking time off to have children. It is important for employers to recognize the value of their female employees and provide them with a safe and supportive work environment by enforcing workplace laws and promoting gender equality. India can create a more inclusive and prosperous society where women can thrive and contribute to the country's growth. Thank you.